Thank you.
Good morning, Virginia.
Good morning.
Good morning.
Good morning. There we go.
Well, I think by now you know the drill, except that we've changed it up a little bit. This is Unit 5, and we got to talking, and we didn't like the question, so we came up with our own. Other than that, everything else is going to be the same. We'll introduce ourselves, and then you can introduce yourselves. Judge?
I'm Hank Chambers. I'm a law professor at the University of Richmond.
And Judge?
I'm Steve Levinson, and I am a happily retired state Supreme Court justice from Hawaii.
And I'm Jerry Bass, and I haven't reached that happiness yet. I'm a district judge from Oklahoma. Criminal docket's my responsibility. And I've had the honor and privilege, as my colleagues have too, of having come up here and judged this 4 times before, and it really is an honor and a privilege to come up here and be with you all. Would you introduce yourselves?
Sure. My name is Dylan Kohlhoff. We're all seniors at Nagy L. Walker Governor's School in Richmond, Virginia.
I'm Katie Ardith.
I'm Dallin McNerney, and this is our coach, Mr. Matt McGuire.
Very good. How about question number 3? We need procedures that translate the values of Fourth Amendment with its warrant requirement into a new technological context. Do you agree or disagree with this claim by a legal scholar, and why? What values are inherent in the Fourth Amendment, and why are they important? Some scholars argue that government can use surveillance data collection and data mining technologies for good purposes, such as keeping America safe from terrorist attacks, preventing crime, and delivering social service. Do such uses outweigh possible negative uses? Why or why not? You may begin.
The Supreme Court stated in Silverman v. U.S. that the Fourth Amendment and the personal rights it secures have a long history. At the very core stands the right of a man to retreat into his home and there be free from unreasonable governmental intrusion. The Fourth Amendment uses the searches and seizures clause, as well as the warrant requirement, to highlight 3 core values for the protection of citizens. These include privacy, a check upon the executive, and a check upon the legislature. First, the Fourth Amendment promotes privacy by allowing individuals to be free in one's thoughts and ideals within the sanctum of one's person and home. Second, the Fourth Amendment places a check upon the executive. Police officers and prosecutors must obtain evidence lawfully with judicial oversight. Third, the legislature is discouraged from enacting unreasonable laws and statutes that invade one's privacy. In Katz v. United States, the Supreme Court held that the Fourth Amendment protected people rather than places. This was necessary because wiretapping allowed law enforcement to invade the privacy through telephone communications. The court ruled in Kyllo v. United States that law enforcement's use of thermal imaging equipment was a search that required the use of a warrant. Katz and Kyllo are 2 cases in which the Supreme Court adapted jurisprudence to address the new issues presented with technology advancement. Further procedures are necessary to clarify and modify the application of the Fourth Amendment.
The application of the plain view doctrine in relation to technology has been extended beyond its original intent, and the court should require that officers obtain an additional warrant that follows the particularity essential to the warrant requirement in the Fourth Amendment. In the Seventh Circuit Court of Appeals case of United States v. Mann, defendant Matthew Mann was accused of possession of child pornography using evidence obtained while searching his computer for evidence of an unrelated crime of voyeurism. Although this overextension of the warrant was ultimately declared constitutional by the Seventh Circuit, an additional warrant should have been required. In the cases of United States v. Miller and Smith v. Maryland, with the third-party doctrine that they created, we find another area in which the values inherent in the Fourth Amendment are in need of better protection. In modern technological times, private information is shared in abundance through savings cards and phone, bank, and medical records. Although businesses are private entities able to do essentially anything with private information without violating the Fourth Amendment, the government should have strict guidelines pertaining to how the executive can get information from third parties. Although this is, according to Miller and Smith, not a Fourth Amendment issue, legislative action is essential to protecting the values of the Fourth Amendment. The information that officers can seize incident to arrest has also been expanded with increased capabilities of cell phones and PDAs to hold vast amounts of personal information. The Founding Fathers could not have conceived of this great mobility of these papers and effects So procedures should be created to limit the scope of what information may be extracted from the devices.
This age in American history is unique in that government has both the ability and the responsibility to engage in preventative security measures as opposed to punishment after the fact. These measures, including data mining and surveillance, are considered useful tools in creating profiles for suspected terrorists or dangerous criminals. The advantages of using these technologies is clearly to uphold national and personal security, which must be weighed against the great cost of privacy. To best protect both, a balancing test must be applied which looks at the magnitude of the threat, the effectiveness of the security measure, and the degree to which privacy is invaded. For although privacy is important to forging an innovational citizenry, the Constitution must also protect national and personal security. As Justice Robert Jackson said, the Constitution is not a suicide pact. Thank you, judges. We are now ready for your questions.
What balancing test do you suggest?
I think that it really has to be a sort of case-by-case basis in which you look at, yes, the privacy that will be invaded and the security that could be really the threat to security. Of course, I think that one of the essential things that we add to this is how effective that security measure is, and I think that this is often not really looked at in many cases.
In the text of the Fourth Amendment, we clearly see...
Excuse me for just a moment. Let me just follow up. So it depends on how effective the technology is, whether it should invoke the Fourth Amendment or not? Is that what you're saying?
Sorry, I must have misspoken. Excuse me. I think that the balancing test, it needs to look at how effective. I think the Fourth Amendment is always in effect. However, you have to look at how effective the security measure is to whether it is that balancing test, whether the security outweighs the great cost of privacy.
We in the Fourth Amendment, we look at unreasonableness as part of the doctrine. So what we're essentially doing in the balancing test is seeing the reasonableness of the search in comparison to the evidence that you're looking for.
If we look at New York post 9/11, there were baggage checks going onto the subway without individualized suspicion. Although these measures were very invasive to one's privacy, I would contend that they were not very effective in protecting the citizens.
If you look at, there are many instances in history, I think, where you see the same issue, where the security measure was not actually effective in protecting the security. I think Kuramatsu, of course, the Japanese internment, Palmer raids, cases like this, where the judicial branch, I think, sometimes failed to look at how effective the security measure was.